this EU settlement scheme is an attempt to put in a system which will be as simple and streamlined as possible. So it's not really like a usual visa application scheme that you would experience under the UK system. And the important thing is its provisions are, if you like, more generous than those set out under the withdrawal agreement. So as you'll be, EU free movement at the moment allows for residents, if you are going to be economically active, or there are various requirements that you have to satisfy, and particularly if you want to obtain permanent residence at the end of 5 years. In most countries, you would need to show that you had been lawfully there, and that would mean some sort of economic activity or being economically self-sufficient or a student, and providing proof of that activity during your 5 years. By contrast, the EU settlement scheme is much more straightforward than that. And in simple terms, what the provisions say is that for those EU citizens that have been living in the UK, who arrive in the UK before the 31st of December and continuously resident for 5 years, they are eligible for settled status. But they would not have to demonstrate what they have been doing during those 5 years. It's purely about showing residence, which I think is a key difference. So in that sense, it's very much a simplification on EU free movement at the moment. And then for those who are resident by the end of this year, but won't have been here for 5 years by the time they will apply, they will be eligible for something called pre-settled status. And when those individuals with pre-settled status have been in the UK for 5 years, they will be eligible to go on and apply for settled status. And the deadline for making this application in line with the withdrawal agreement is the 30th of June next year. So there's a kind of 6-month grace period after the deadline for having arrived in the UK, which is significant as well. And I'll explain that in a bit more detail later on. To explain in a bit more detail what settled status and pre-settled status means. So settled status is the equivalent of permanent residence, also known as indefinite leave to remain in the UK. It means someone has an unrestricted right to live and work and obtain, benefits in the UK. Having got that status, they could, if they wanted to, then go on to apply to naturalise as a British citizen after holding that status for 1 year, but there's no obligation for them to do so. Effectively, once you have settled status, you have the freedom to come and go, and you, in UK immigration terms, you're not subject to immigration control. Pre-settled status, on the other hand, is the equivalent of having a 5-year visa. It is a form of limited leave to remain, to use the UK terminology. That type of status will be granted to those people who haven't, are not eligible for settled status. And the important thing to note is that would generally only be granted once the deadline has passed. So when an individual is granted pre-settled status, after the deadline for applications has passed next year, they will hold that for 5 years, or they will be given 5 years leave, and at the end of that period they must either apply for settled status or switch into some other immigration category. They would not be eligible to apply for another 5 years worth of pre-settled status as a sort of like one-time visa. And in either case, whether you've got pre-settled or settled status, it means that you have access to the same rights and benefits as an EU citizen as you would now, as well as your family members, whether they are EU or non-EU nationals. And importantly, once you're granted settled status, that is, you won't generally lose that status unless you are outside for a continuous period of 5 years. And that continuous 5-year period could be broken by even a one-day return to the UK. So it would be quite difficult to kind of have settled status and then lose it. So in terms of how someone goes about obtaining pre-settled or settled status, as I mentioned, it's an application, but it's more akin to a registration process. It's unlike any other visa application. The Home Office here have said that they will in most cases, they will try to give people the benefit of the doubt. If the right information isn't provided initially, they will contact the individual to obtain further information, which is in stark contrast to the normal visa process. It's clearly in the UK government's interest to push to make this as easy as possible, and for those people who were already resident in the UK to gain their status as soon as they possibly can. And the way that this status is obtained is mostly by using an app on a mobile device. So is relatively straightforward. We've sat with lots of individuals while they've gone through the process. It's something that's designed for individuals to actually do themselves, and in most cases they can do that without any sort of legal support. And basically you have this app on a phone, you open it up, you use the app and the phone to scan the ID page on your passport, and then you scan the microchip in your passport, and the process kind of prompts you to take a photo of yourself, and then you complete the rest of the process on a personal computer, and that asks you some more personal information. But it's really quite straightforward. In a lot of cases, the whole process can be completed in sort of less than 15 minutes. The individual at the initial stage is not required to provide any other documentation apart from their passport or their biometric residence permit if they're a non-EU national. The key bit of information that they would usually provide is a national insurance number, so their social security ID, if they have one. And having provided that number, the system works so that the individual, it's literally within the space of a few minutes, in most cases, the Home Office can confirm whether or not that person has or has not been in the UK for 5 years already. So in some situations, someone who's already been in the UK has kind of a tax presence, and HMRC, which is the tax authority here, has a record of their presence in the UK. Having given their national insurance number, the system will come back to them and say, yes, we recognise that you've been here for 5 years, you're being considered for settled status. And that's the end of the process. And then approximately 5 days later, they get a confirmation saying that their settled status has been confirmed. So that's what happens in the most straightforward of cases. If someone has been here for less than 5 years, then the system will say, we think you've been here for less than 5 years, and so we're going to grant you pre-settled status. If you disagree, you can provide additional information to show that you have been here for 5 years, and that's things like tax documentation or employers' letters over a period of 5 years, or leases or bank statements. There's a whole range of sort of supporting documentation they can provide. And so that would be submitted, scanned and sent by email to the Home Office. And then again, eventually the Home Office may say, right, okay, we acknowledge that you have been here for 5 years. So it's that sort of automated process. And when it works well, it's very, very efficient. We found that in the cases which are more problematic is when we're dealing with non-EU family members who have residence here on the basis of their relationship with an EU citizen in the UK. And that does become more problematic, particularly if you have to prove the relationship between the EU citizen and the non-EU citizen. For example, if they're not married, they've been living in a relationship akin to marriage for 2 years, and so you have to provide extra documentation. So that is when it can become more complicated. And I've no doubt that there, and clearly the cases we are dealing with are via most often via employers and helping their employees. So all of these individuals have a sort of tax presence, if you like, in the UK already, which makes the process much simpler. There will be other individuals who don't have national insurance numbers, or vulnerable individuals who need more help to apply and have a sort of more complicated background. But that's it, the process in a nutshell, and there are no application fees. So this is all part of the UK government's drive to encourage as many people as possible to apply under the scheme. And I've got a few statistics here, which I think are quite interesting. So as of the 30th of June of this year, there had been 3.4 million applications under the scheme concluded. 57% of those applications were granted, resulted in settled status being granted, and 41% of those applications resulted in pre-settled status being granted. So it's about half and half, roughly half and half. And then I understand that there is just over 1%, between 1 and 2%, which come under the umbrella heading of other outcomes. So that could include refused applications, withdrawn applications, or invalid applications. So it's a fairly high approval rate. And then also, which I think is quite interesting, the top 5 nationalities who've applied under the scheme in descending order are Polish, Romanian, Italian, Portuguese, and Spanish. So that gives you the idea of the nationalities that are applying. So that's really the kind of the settlement scheme in a nutshell. I mean, I'm sure people will perhaps have additional questions, and I'm happy to sort of talk about that in a discussion afterwards, because I've really, I've given you a kind of a summary. In terms of discussing the transition, how the settlement scheme works with the future immigration controls, which is the new points-based system. I think this slide's quite helpful. It's just to set the scene in terms of where we are and how we transition from one to the other. So at the moment, we are in this towards the end of this green period and the end of the transition period, coming up towards the 31st of December. Those who have arrived in the UK before that cut-off point will be eligible, if they've been here for 5 years, to apply for or to obtain settled status, and those who've been here for less than 5 years should be granted pre-settled status. And then we've got this cut-off point of the 31st of December, after which new arrivals from that date will be subject to future immigration controls. So that could be the points-based system if they're coming here to work, or it could be the UK's existing immigration system, whether that's coming here as the spouse of a British citizen or coming here as an investor. But either way, the key obviously is that EU citizens will be subject to these future immigration controls. And then just to reiterate again that even though the cutoff point for being resident in the UK to get settlement is 31st of December, the deadline for applications is not until the 30th of June, so 6 months later. So then moving on to talk about the new points-based system, I think it's helpful to kind of summarise what we currently have. And that is something called, for work employment purposes, that is something called the Tier 2 sponsorship system. And that is currently divided into 2 key categories. So we have Tier 2 ICT, or intra-company transfer. So that's for employees who work for a group entity outside the UK and have, there is a sister company in the UK that has a sponsor license. And so individual employees can be transferred can obtain a work visa under these intra-company transfer provisions quite easily. So that's a key route. And then the other main route is called Tier 2 General, which is usually used for new hires to a UK business. And it usually requires the UK sponsor to complete something called the resident labour market test. So to demonstrating that there is no one else in the UK, resident in the UK, that can fill that role. So if you like, to protect the UK resident workforce. And both of those categories have minimum skills and salary threshold. So that at the moment, the skills threshold is around degree level or above to be able to obtain a work visa. That doesn't mean that the individual has to have a degree, but it means that the role that they will be doing when they are sponsored in the UK must be skilled to that level. And then with that comes certain minimum salary criteria. So if we're assessing whether someone's eligible for sponsorship, we will ask that the employer to provide a job description so we can match that to an occupational code. And then that will confirm whether or not the role is sufficiently skilled and what the minimum salary is. And then the sponsor uses that information to create something called a certificate of sponsorship. They assign that themselves, and then they provide this to the individual to obtain their visa from either from their home country or from within the UK if they're eligible to switch immigration status. And the reason why I'm talking so much about the current points-based system is that you'll see that it's that the new system, in inverted commas, is actually not significantly different. And I'll go on to explain why. And then one of the interesting, well, problematic issues around sponsorship and UK visas is that they are both subject to specific additional charges. So this is in addition to the application fee itself, known as the immigration skills charge and the immigration health surcharge. And that they are quite expensive. So the immigration skills charge is generally for a medium or large employer, £1,000 per year of the visa, and the immigration health surcharge is £624 per year of the visa. So for each application, there are significant costs that have to be paid on top. And it's very clear from the UK government's policies that they are going to use cost as an effective, increasing the fees and the cost of applying for visas as the effective way of keeping numbers down, rather than the complexity of the system. I think they've realised that that's the thing, apart from the fact that it makes money for the UK government, but it's an effective way of keeping numbers down. So that's what we currently have. And then under the new, so to talk about the new system and how that compares. So obviously the important thing is that the current system only applies to non-EU citizens. Going forward, the new system will apply to non-EU citizens and EU citizens in exactly the same way. The government has made it clear they want to create a level playing field for all non-British applicants. And rather than being an entirely new system, it is actually a variation of this, a rebranding, if you like, of the system that we currently have. In the early days after Brexit, there was talk about a sort of, in terms of the immigration control to which EU citizens would be subject, there was talk of a kind of like a light touch registration system, or a separate system for EU citizens compared to non-EU citizens. But that idea was sort of discarded, I think, about 2 years ago. And the premise is very much that it's a level playing field for all non-British nationals. And the scheme will be divided into two categories. So skilled worker will replace the current tier 2 general system, and then we will retain the current intra-company transfer category. Mostly the system will be employer-led, by which I mean that it won't be possible to get a work permit unless you have a UK sponsor. There has been talk about introducing a particular type of visa which an individual would obtain by themselves, for example, because they have a degree and a certain level of earnings, and it's their own visa, and then they could come to the UK and effectively work for any employer. So there is talk of that, and we had something like that a few years ago called Tier 1 General, and that was abolished in 2012. But there is talk about reintroducing that type of system for highly skilled. And there is also another visa called Global Talent, which is for very, very super sort of extraordinarily talented people. But that's actually it's not used, and it just doesn't really apply to most people. But they are discussing bringing in another type of visa, but we have no detail on that. And I think that may be perhaps a year or more before that's introduced. So in the meantime, what we are left with is this this employer-led system. And that really, you have to have a UK entity to be able to obtain that, or sponsor an individual coming from the EU. So the next two slides are talking about what the key qualifying criteria are. And so importantly, the salary threshold for a skilled worker visa, which is the main visa category that people will use, is being reduced. So a lot of the changes that are taking place are things that are making it easier to sponsor EU and non-EU citizens going forward. So for those employers in the UK that already are used to using the sponsorship system and accustomed to sponsoring non-EU citizens, a lot of these changes are actually going to be very welcome. It will be a simplification of the process and a lowering of the criteria. So it's strange in a sense that we're leaving the EU, but this is kind of immigration driven, and yet we are opening up the immigration system to a far, far bigger group of, profile of worker than currently exists for non-EU citizens. So the salary threshold is being dropped to 25,600. There are exceptions. So in some cases it will be lower than that, and in some cases that threshold will be higher because it will still be subject to the going rate for that specific role. So for example, if you're an experienced IT professional coming from the EU, in order to be sponsored, you would still need a salary of around £45,000. So there are kind of different varying thresholds depending on the actual role that someone will be doing. And then, as I mentioned before, we have a lowering of the skills threshold. So at the moment, you have to have you have to be at graduate level or above to qualify for sponsorship, and they are now reducing that to RQF level 3, which is the equivalent of if you've got skilled to the end of A levels, the end of secondary school. That is the sort of lowering of the threshold. So it means that a lot more workers than currently the case will qualify for sponsorship. And importantly, they are getting rid of what is called the resident labour market test. So again, this is another way in which sponsorship will become significantly easier, because the employer will no longer have to justify why it has chosen, for example, an EU citizen for the role over a British citizen. So that's sort of welcome news for a lot of employers. They have suspended the cap on the number of visas that can be issued each year, although by saying that it's suspended, it implies that a cap, if necessary, could be reintroduced. And importantly, for applicants, there's an English language requirement. So that either requires that you've come from an English language speaking country, that you have a degree that was taught in English, or that you will have to sit a prescribed test in order to show your English language level. And again, there are immigration skills charge and health surcharges that will apply to the process. Again, importantly, this will be the mechanism for keeping a cap on numbers. I suspect the government would just make it more expensive if the visa categories are being used at too high a rate. And then the intra-company transfer route will be retained very similar to how it is now. And it used to be under the current system that the key difference between tier 2 general or skilled worker and intra-company transfer was the presence of this resident labour market test, because there is no resident labour market test for the intra-company transfer route. So it begs the question of, there is very little difference now between the two visa categories. And in most cases, people will want to use the skilled worker route because that is a route that can lead to settlement or indefinite leave to remain after 5 years in the UK, whereas the intra-company transfer route does not allow for that. So in most cases, I expect that people will favour the skilled worker route over intra-company transfer route, apart from the fact that there is no English language requirement for the intra-company transfer route. So that is the one aspect in which it may be more appealing to certain categories of employee. So that brings me to sort of discussing how employers should prepare for the new system in a practical sense. So many employers will already have a sponsor license, which enables them to issue certificates of sponsorship. And that is the sort of overarching permission that a UK employer must have in order to apply for work visas. And that license lasts for 4 years and is renewable every 4 years. So for those organisations that don't already have a sponsor license, they should apply for one now so that they can use the new system. The new system is actually going live from the 1st of December in preparation so that applications can be submitted and approved before the kind of the effective date of the 1st of January. For those organisations that do already have a sponsor license, they should ensure that they've sort of carried out in-depth compliance audits, because the Home Office is now beginning to carry out more audits. Because of COVID restrictions, they are now doing these by phone, which is kind of makes it more convenient, but it also means that they are happening with more frequency. So that's something that current sponsors should be aware of. in order to sort of make sure that they have their house in order from a compliance perspective. And then, you know, in terms of if you had an individual who is anticipating making an application, you wanted to hire an employee under the new system, you would be the process in terms of, you know, where you submit the applications and how long you have to wait for, what documentation you have to provide is very, very similar to what you would provide now. So you would sort of almost proceed as you would for a current visa application. In anticipation of the new system, it would be worth looking at the candidates' sort of English language level, and in some cases, depending on the country they're coming from, they would need a TB test prior to travel. So it would be worth kind of assessing that aspect of it even before you start making the application itself, in order to save time when the new system opens on the 1st of December. In addition, employers, you know, sort of existing sponsors within the UK should be identifying in the couple of weeks we have before the system opens, you know, going forward, they are accustomed to not having to sponsor EU citizens. EU citizens can, if you like, come and go freely. You know, from a workforce perspective, the employers should be considering, well, you know, how is this going to change? How is this going to impact our systems? Have we made provision for the extra cost of having to, you know, we want to continue recruiting from the EU. Do we have the resources in place to deal with the extra applications and the cost that incurs? So that sort of prior assessment is quite important. And then looking at it from a different perspective, if you are looking at candidates at the moment in recruitment processes, you know, if that individual can be brought to the UK before the 31st of December, then that would be a legitimate way of avoiding having to get them sponsorship, because they don't even have to start work before the 31st of December. It would be about genuine, you know, just being physically resident here before that cut-off date. And then they would be eligible to apply under the settlement scheme rather than having to go down the points-based system route. And then in the meantime, employers should continue to support their existing EU workforce, because although, you know, I read out some numbers that indicated that many millions of people have applied under the scheme, it's clear that some people haven't yet applied. And although the deadline is not until the 30th of June of next year, there isn't, I mean, I suppose some people may want to wait because they are approaching their 5-year anniversary, so they're almost eligible for settlement. But the system is, you know, it's free to apply, so there's nothing to stop you applying for pre-settled status now, reaching your 5-year anniversary in March of next year, and then making another application then. My concern is that you know, in the months leading up to the 30th of June, which is the deadline, there might be a surge of applications. And given all the changes that are going on within the Home Office and the difficulties that we've experienced in relation to COVID, you know, we don't know how the Home Office is going to cope with, you know, over the next 6 months. So our advice generally to employers is to encourage their affected staff to apply as soon as possible. And then importantly is sort of educating the rest of the business about these changes, because obviously there's a lot of focus on what Brexit means for a business, but everybody has their own sort of different parts of Brexit that they are looking at, and some of these changes are significant. So there should be sort of, as far as possible, there should be pushed to the top of the agenda in terms of the changes and the cost implications that this is going to have within a lot of businesses throughout the UK. And then just I would mention on a final note for, and I have a few more slides after this talking about other practical issues, but it's worth noting that for EU citizens that aren't resident in the UK and not intending to work kind of properly in the UK from the 1st of January, they will still be able to enter the UK as visitors and attend, you know, come to the UK without needing to get a specific work visa to attend business meetings, for example. As far as I'm aware, unless the remaining EU discussion, Brexit discussions go very badly indeed, it's a reciprocal intention that EU citizens coming to the UK will be treated as non-visa nationals, and similarly UK citizens going to the EU. So it means that EU citizens can continue to come to the UK as visitors if they are entering for the purpose of permitted business activities. So generally that means, attending meetings and conferences. There are some quite generous provisions when it comes to visitors who are coming, who are kind of, if you like, traveling for business within their group of companies. So they're from a sister company in the EU coming to visit a sister company in the UK. There are some sort of fairly helpful provisions about the additional permitted activities that someone coming in that situation can do beyond work meetings, business meetings. So that's worth bearing in mind. And from my sort of experience in looking at this, those provisions are quite generous compared to other. I haven't seen an equivalent of that sort of wider permission to do work in the UK as an intragroup employee. I haven't seen that reciprocated throughout the rest of Europe, although, to be fair, I haven't analysed all 28 countries in terms of business visitor rules, but that is a provision that maybe most people don't know about. And for EU citizens from January, that may be quite useful, because obviously you don't want to have to get somebody a work permit unless they absolutely need it. And there's always this grey area about what work can someone do as a business visitor. So I think that's worth bearing in mind. And then I'll also talk briefly about the right to work checks that will apply, and the slight sort of confusion I think that may arise in the next 6 months from the 1st of January. So of course, we'll have properly left the EU at the end of this year, and the new points-based system will apply to EU workers arriving from that point. Those already in the UK before the end of that period will be eligible for pre-settle or settle status, but the deadline for applying for that status is 6 months hence. So if you like, we're going to have this slight overlap between January and June. Individuals who are granted settled status or pre-settled status won't be given a biometric residence permit. It will be proved online only, which is slightly controversial, and it has been various people have tried to challenge it out of concerns that people will be undocumented. But for the moment, the status will be proved online only. And interestingly, the Home Office has said that if you are conducting a right to work check, so as a UK employer, ensuring that somebody has the right to work before they start work, from the 1st of January, that would still be a check that if an EU national presented themselves for a role from the 1st of January, you would still carry out a check on their EU passport. And if they presented you with an EU passport, that would be sufficient to proof of their right to work. And they cannot require an EU citizen to prove that they have pre-settled or settled status until after 30th of June 2021. So that creates a slightly strange situation, because at the same time we're also saying the points-based system applies from the 1st of January. So a lot of employers have been asking, well, does that then create an obligation on the employer to inquire of this new candidate, or when did you arrive in the UK, so I can establish whether or not I need to sponsor you? And the Home Office, they need to come back and clarify this formally. Informally, I have been told by the Home Office, no, there is no obligation on you to check when someone arrived in the UK. If they present an EU passport, then that is sufficient for right to work purposes, and you don't need to sponsor them. That is making a lot of employers quite uncomfortable, but the Home Office has said that if an employer that employs somebody on that basis will not be penalised if it later transpires that somebody should have applied for settlement and they hadn't. From a legal perspective, we think there is a risk that if you actively knew someone isn't eligible for settlement and you continue to accept an EU passport, then you would be at risk of some sort of penalty. But that's something that we're going to have to get clarity on from the Home Office. And unfortunately, along with a lot of the other changes that are happening at the moment, the relevant guidance is being published right at the last minute. So we're somewhat in the dark from a legal perspective. And then on top of that, so that I've just been talking about new arrivals from the 1st of January, but the Home Office has also specified that employers should not be carrying out checks on their existing employees to see whether or not they have pre-settled or settled status. So if you like, the point at which employers will start requiring employees to demonstrate that they have pre-settled or settled status will only begin really on the 1st of July of next year. And prior to that, it's up to the individual to obtain their own status. And then from the 1st of July next year, that is when employers will be asking individuals to confirm what their position is. So I think that brings me to the end of my talking bit, and I hope that's been helpful in terms of covering the key aspects of the settlement scheme and the points-based system. I'm very happy to take questions if anybody has any.